Okay, perfect. So again, thanks to Professor Marcos Orellana, who is the UN Special Rapporteur on Toxics and Human Rights and adjunct professor of international environmental law at George Washington University. He's a well-known expert in international law and the law on human rights and the environment. And he has an extensive experience also as a legal advisor in a wide variety of institutions, including United Nations Agency, UN Environment Assembly, and the Human Rights Council, and intervened in various cases. And here we have both before courts that are typically within the domain of environmental law and human rights, but also the World Trade Organization appellate body. And he has engaged also in other ways with institution of international economic law. Professor Orellana has also experience with working with civil society, and he teaches at university. We are very, very pleased to have you for your knowledge, but also as experience and for putting this knowledge into practice. We were recalling this morning that we are undergoing an environmental crisis. It is important to mobilize all sectors of law, and also as academics, we feel a particular commitment and engagement with the challenges of today's world. So we are very grateful that you could share with us your wisdom and experience today. The title of Professor Orellana lecture is The Unfinished Agenda of Stockholm 1972, a rights-based approach to international environmental law. And we will have about 30 minutes of speech and then time for Q&A. So thanks again, the floor is yours.
Thank you very much, Professor Arcuri. I am the one that's honored to join the program on such critical issues for humanity. The basic premise of my talk today is that international environmental law is the result of an overly state-centric view. And it is not achieving its objectives. It is not achieving its objectives because it is fundamentally misaligned. Now, the fact that international environmental law is failing us, humanity, means that we are facing the severe triple crisis that you spoke of just now, of pollution, climate change, and biodiversity loss. But there's a way out, and that's where the right to science and the right to a healthy environment can help inject a rights-based approach to multilateral environmental agreements and international environmental law more generally. This is what I call the unfinished agenda of Stockholm 1972. So with this basic premise, I'll proceed to unpack all of that in the next 25 minutes. I must apologize, this is allergy season for me. If I need to take a break because of sneezing, you'll, I'm sure, understand. Thank you. So international environmental law began to develop in earnest since the 1972 Stockholm Conference on the Human Environment. This was the first time that humanity came together to address issues of environmental issues of common concern. Before that, certain environmental issues had been addressed under the lens of natural resources, but never in a comprehensive manner, portraying a common awareness of humanity regarding our common home. Now, there were several competing currents in Stockholm. The north-south divide was beginning to become quite apparent. In the preparatory works, we see speeches of how environment should not become a form of conditionality, or how it should not constrain the development process. Those were the seeds of the paradigm that was to mature in the years after Stockholm of sustainable development, the integration between environment and development. And within that, or in relation to that, or even alongside that, there were currents of human rights. Human rights were not absent in Stockholm. We can see them informing the preparatory works, the statements of countries that participated, other participants. We can also see it in the narrative that the conference offered by the way of the Stockholm Declaration on the Human Environment. The preamble of that declaration, the principles, specific principles that are focused on human rights, they all speak to the relevance. But it was not the only approach. There were competing approaches, as I'm saying, and one of those is the environmental sovereignty and sovereignty over natural resources. So state-centered view about the prerogative to determine environmental policy. Now that has had profound implications for the development of international environmental law. The instruments that were developed in the wake of the Stockholm Conference, especially in the chemicals and waste cluster, I'll focus more on that, exhibit this horizontal dimension of state-centric international law, where states talk to other states and come up with management frameworks to deal with shared risks. And only those issues where there is a clear hook internationally that can justify international intervention are addressed by international environmental law. As a result, there are many issues that begin to fall through the cracks because the hook for international law to capture them is not there. In this evolution of international legal instruments, we see parallel tracks as well. Professor Arcuri was mentioning economic law in her kind presentation of my previous work. There we can very clearly see how trade law developed what has sometimes been called splendid isolation without much regard to what was happening elsewhere. We can also see how human rights and the environment developed in very separate tracks and with at times quite different assumptions and premises. So as I'm saying, if international environmental law exhibits this horizontal dimension of international law, human rights presented a vertical dimension where international law would be concerned of what was taking place within the nation state in regards to the state's treatment of the individual and group's fundamental rights. So the fact that there were these parallel tracks meant that there was not much opportunity for normative dialogue between instruments and for cross-fertilization. We see also that, as I was saying, the basic premises of these instruments differ. So while in human rights terms, the position, the vantage point is that of the individual and in respect of collective rights, peoples or local communities. When it comes to environmental issues developed in the wake of Stockholm, the vantage point was the state-centered view of management and control of pollution to minimize harm. Under that frame of controlling pollution, very heavily influenced by the internal environmental law developments in the United States after Earth Day. So the command and control, this management and control of pollution. The point was not to secure an environment free of toxics and waste. It was more of controlling, of minimizing. Now, this approach meant and means still that some people will be and are sacrificed. Their rights are sacrificed in the pursuit of economic activity. And from a human rights perspective, that result is incompatible with the basic premises of international human rights law. So we already begin to see a clash, perhaps not a conflict of norms as such, in that states may may be bound by norms that they may be able to pursue in parallel terms, but certainly a clash of objectives, a clash of underlying premises. In the premise of management and control, it is the political process that will define environmental quality standards. So there's no association necessarily with the right to science. There's no necessary association with the right to a clean, healthy, and sustainable environment. Rather, we're left with the nation state exercising its sovereignty through its political processes to determine what are the environmental standards that it considers, the state considers, relevant for its particular situation. In that context, we see that some states have enacted standards that are not protective sufficiently of human health and the environment. On the one hand, at the same time, we see that it is often the case that state sovereignty is a veneer in the face of weak governance or corruption that begins to erode the public interest legitimacy that would otherwise quote these standards. Instead, standards have been a device to legitimize the environmental destruction of the planet, perhaps if I can be provocative. So this is a heavy critique of environmental law as it has unfolded since 1972 in Stockholm. If I can continue to be provocative, many international environmental law treaties can be described as voluntary treaties. So this is a new category or typology. Those of you that may have already taken public international law will be familiar with certain categories of treaties, in the synalagmatic, objective treaties, the treaty law, the multilateral treaty. Well, we're seeing now a new category, perhaps, of the voluntary treaty. So the treaty that's binding in paper, but does not really bind because the norms are so soft, not necessarily soft law as in a non-binding instrument, but the norms are so diluted, they're so qualified, they're so contextual that the agreement does not really bind. Norms that do not oblige. Now, there's a lot that could be said about this in respect of the symbolic value of international law, but I think the point that we're mostly interested in today is effectiveness. Effectiveness because we have instruments that are not delivering on the results that we need. Climate change is rampant, biodiversity loss is a catastrophe in the world, and people are exposed to high levels of pollution. Just yesterday, the Lancet Commission on Pollution and Health released its new report documenting that 1 in every 6 deaths is caused by exposure to toxics. Now, this is a fundamentally incompatible situation with the guarantees of the right to life in human rights law. How did we get there? We have also earlier, a couple of months ago, seen a report of the Stockholm Resilience Center that has elaborated on the theory of planetary boundaries, documenting how humanity has surpassed the planetary boundary of pollution and chemicals. This means that the toxification of the planet is not only impairing our ability to lead lives of dignity, but it is also compromising future generations. And this is not even to mention climate change as an existential threat of humanity, as the Intergovernmental Panel on Climate Change has clearly laid out. If I can go back to this idea of voluntary treaties, the misnomer is apparent. A treaty in the Vienna Convention on the Law of Treaties is defined inherently as an instrument that's binding, but here we have voluntary treaties. We see that various MEAs, multilateral environmental agreements, they utilize the tool of national action plans in order to achieve their objectives. They can call it NAPs for the acronym. The Paris Agreement calls it NDCs for nationally determined contributions to meet the global mitigation goals. These NAPs are quite attractive for states because they offer flexibility to tailor measures that can cater to national circumstances and capabilities. But the question really for us in this conversation today is, do they work? Are they effective? And if we look at a couple examples, well, the Paris Agreement for start, the UN Environment Program's emissions gap report documents that even if all pledges in NDCs were to be achieved, which is already an unlikely situation, we would still miss the target of the Paris Agreement and go to a world of 2.7 and above centigrades, above the pre-industrial revolution. Now, anything above 1.5 Celsius, as the IPCC has documented, will bring havoc to the world. It will mean hundreds of thousands of, or even millions of people displaced, hunger, water scarcity, sea level rise, so states disappearing, and so forth. What does that have to say about human rights? Self-determination, right to life, right to food, right to water. So here we have a first example of NDCs being a high-stake gamble that's not paying off. If we look at other examples, the Stockholm Convention on Persistent Organic Pollutants that was adopted in 2001. Let's recall, persistent organic pollutants, as the name already indicates, they persist. They do not easily degrade. They are also capable of long-range transport. They move around. And so this is a global problem. And they are hazardous, or even very hazardous. Dioxins, for example, being some of the most hazardous substances known to humans. So the Stockholm Convention resorts to national action plans when it comes to the control of unintended POPs. Which are unintended POPs? Those that result, for example, from incinerators, incineration to burn waste. Here, the obligation is not to reduce the number of dioxins or POPs in a quantified manner, but the obligation is to enact or elaborate a national action plan. And there will be elements of best available technologies and so forth. So in that situation, so the number of incinerators, instead of going down, and the number of POPs that are being unintendedly produced have been increasing. So do they work? The most recent documents of the Stockholm Convention regarding effectiveness, has, even 20 years after adoption, have not been able to quantify whether these NAPs have been effective. And the last example that I thought I would offer is in the Minamata Convention on mercury. NAPs are used to deal with so-called artisanal and small-scale gold mining, which may be small in the scale at the individual level, but it has nothing small about it because it's the worldwide largest emitter of mercury to the air, to the waters, to the environment. Now, mercury, as we know, is a very dangerous, hazardous heavy metal that also persists. It doesn't go away. That can cause all kinds of very serious health complications, including loss of life. So do NAPs work? If we look at a couple of case studies, as the mandate does in Latin America, in the Amazon, or in West Africa, or in Southeast Asia, we see that small-scale mining and use of mercury is going up. It is not going down. And the human rights implications of this are severe. The dumping or the release of mercury to waterways, to rivers, upon which indigenous peoples depend for their livelihoods, for their water, for the fish they eat. This is an ostensible case, a situation of global environmental injustice, a clear case of human rights violations that indigenous peoples are suffering. To be able to visualize the magnitude of the problem, imagine yourselves bathing, drinking, washing, day in and day out with water that you know are contaminated with mercury, with dirty waters. Imagine eating the fish and giving your family fish to eat that you know is contaminated with water, fish making up the bulk of the diet. So this has implications on cultural rights, the rights to life, the rights to self-determination, autonomy. So the result that environmental law, as it has unfolded since Stockholm, because of this misalignment, because of its misaligned objective of management and control, and because of its increasing voluntary character, is failing, and it is legalizing the gradual destruction of the planet. This is a heavy critique, of course, and we need to change course. And the way to change course is by looking at key human rights that concern the protection of the environment. And there are two human rights that I think are particularly relevant, and I wish to expand on them in a few minutes. The first one is on the right to science. Here we see, on the right to science, we see a gulf, real gulf existing between the science on chemicals and wastes and regulatory responses. In my last report to the Human Rights Council last September last year, I elaborate on this issue. So I would invite anyone that's interested in further information on that to consult that report. This gap between what the science tells us and the regulatory responses, it is no accident. It is the deliberate result, or rather, it results from deliberate action against science and against scientists, attacks against the scientific project, attacks against scientists. I have documented a number of situations where scientists that speak out to voice the concerns posed by specific chemicals and waste, or classes of chemicals and waste, they are subject to harassment, they are subject to threats, they are defunded, and at the same time, there are attacks against science itself, disinformation for profit. There are firms, consulting firms, other kinds of firms that specialize, that exist in order to create confusion, where mercenary scientists are hired to confuse society. This is a tactic to divert or delay action and to keep the status quo going, because the status quo is very profitable to the clients of these firms that obfuscate the science. These are the 1950s tobacco tactics. It is these papers and tactics are well known when faced with the prospect of regulation in light of increasing evidence of the risks posed by tobacco, not only the smoking of tobacco, but secondhand exposure. The tobacco industry came up with a strategy of presenting alternative explanations. It is not tobacco, it's something else. Well, what else? Well, we don't know, but we need to study. And while we study, we need ever more studies, analysis by paralysis. There's claiming lack of proof. We need to be certain. We cannot act. We need sound science. We cannot act unless we're not sure. And then funding of front groups. So what appear to be think tanks or NGOs interested and concerned about clean air, for example, they are really front groups to carry forward this message of doubt, of uncertainty, of confusion. Now, in the meantime, the result of this is that people the world over are continuing to be exposed to hazardous substances. I spoke about the planetary boundaries, the Lancet Commission, the IPCC. So in the face of all of this, we need to reharness the right to science and bring back its content to the forefront of policy making. The right to science establishes or provides that every person has the right to benefit from scientific progress. Now, how do we benefit from scientific progress? This is where the science policy interface is critical, where information derived from science, including on risks and harms of chemicals and waste, needs to be translated into policy making. Benefits to society do not occur without the translation of knowledge into actual policies, into protections against risks and harms of chemicals and waste. And that is the link that we're seeing missing, where it's not happening. And it is not happening, again, because of a deliberate attack against science and against scientists. Now, there are specific duties that flow from the right, which I think are relevant for our discussion as well. The duty to take measures, not to stand by, but to take measures and align them with the best available scientific evidence. Now, best available scientific evidence does not mean certainty. It means what is at a given time in the realm of science available knowledge to address a specific risk. Another element of content that's relevant here is fostering science, promoting science and scientific research on issues that concern the public interest. We often see, and this has become prominent in the debates about pharmaceuticals, intellectual property, medicines, and so forth, that research goes into drugs, not drugs that are needed in the third world, that not drugs that are affecting millions of people in the world, but they go to the drugs that the highest paying segments of societies can cover. So the profit mode. Now, when it comes to the right to science, fostering scientific research on issues of particular social needs, such as climate change, such as biodiversity, such as chemicals and wastes. There's also an element here of citizen science, the participation of individuals, communities, indigenous peoples in the scientific process under scientific protocols. This is an element that enables agency, it enables empowerment, it involves communities in gathering data, in disseminating findings. It builds bridges with other forms of knowledge as well, so traditional knowledge and so forth. In achieving all of this, the one critical piece is the science policy interface. And there are various models for carrying this forward, science policy interface platforms. I think it's quite encouraging to see that at the global level, the last UN Environment Assembly has decided to establish a new science policy interface on chemicals, wastes, and pollution, much like that which exists in the IPCC for climate change or IPBES for biodiversity. We also have national level SPIs. In MEAs, we have SPIs. Now in MEAs, I think it's also important to point out that some of these do not work very well. If we look at the Rotterdam Convention on international trade in industrial chemicals and pesticides, for example, for years, the Chemical Review Committee, so that's the scientific body under the convention, has been recommending to the Conference of the Parties that it adopt controls. So this is not even a ban. These are controls on prior informed consent, so information sharing and consent before trade on certain chemicals of concern, paraquat, a very hazardous pesticide, chrysotile asbestos, well known to cause all kinds of scientific problems. And yet the Conference of the Parties has failed to act on these recommendations because it has been blocked by the economic interests of certain countries, Russia in particular, and its satellites. And so this is a problem where when design doesn't allow for the objectives of the instruments to be met, because they can be blocked by political and economic interests. Now, when it comes to a global SPI, now it can perform certain roles that are currently missing in the international landscape of chemicals and wastes. And so, for example, horizon scanning. What's coming up? How can we anticipate the threats that are coming up? Authoritative assessments. Is there a consolidated repository in one place where we could refer to an authoritative assessment on the science on chemicals and wastes? This has implications also for access to justice and remedies. And early warning, again, that relates to horizon scanning. And not to mention the functions of dissemination, education, awareness, and public awareness, which ultimately is key to building public support to the kinds of measures that are necessary to reverse the toxic tide that we find ourselves in. Now, all of this said, we do find ourselves also in the risks of corporate capture, and that such a platform could be captured by corporate interest and scientists with inappropriate financial relations. Now, these conflicts of interest would undermine the legitimacy of a global SPI. It would undermine the authority and confidence on science. And so there's a challenge here in the design of this platform to establish conflict of interest norms that can ensure that there will be no inappropriate financial relations. And there's a big debate of whether, given that so much of the, so it is argued that so much of the science on chemicals and wastes is in the hands of scientists that work for chemical companies, could we and could the platform exclude those scientists because of their financial relationships? This is sometimes expressed as the tension or the options between conflict management and conflict avoidance. Management, for example, in that any relations between the scientists and any sponsoring entity should be disclosed. Now, there are several platforms, SPI platforms, that carry forward this model, but they don't work very well, because there's not much time for checking, because sometimes these relations are not disclosed, and because there are no penalties for failure to disclose, because the public is too nuanced for the public to really have the opportunity to conduct and interrogate and hold accountability principles in this light. So the alternative approach is conflict avoidance, and this is what the IPCC does. It's avoiding any semblance of conflict in order to preserve the integrity of the platform and secure its objectives. So in the bottom line, the right to science offers tools to confront and reverse the toxification of the planet, but in order for those tools to be realized, science needs to be transformed into policy. And that is the promise of the right to science. And that is the direction we should move in. In addition, science should illuminate the content of the right to a clean, healthy, and sustainable environment. And this is the last substantive point I wish to make because of time. So here we have what some people say is a new right, because it has only been recently recognized at the global level by the Human Rights Council in October of last year. But the right has been around at the regional levels for quite some time. It is in the African Charter on Human and People's Rights. It's in the San Salvador Protocol to the American Convention on Human Rights. It finds itself a place in other regional instruments, notably the European Convention on Human Rights is lacking any mention, or none of its protocols is also mentioning it. There is a movement in this direction. We'll see how the political process unfolds in the Council of Europe on this. So the right is not a new right. And so on the question of content, how has it unfolded? This is where the right can be seen as an umbrella that brings together the contents of human rights and environment jurisprudence. Now, this jurisprudence, to give it a name, has unfolded for many decades now in the work of the treaty bodies that oversee the implementation of the human rights treaties, that has resulted from the work of special procedures of the Council. So that's special rapporteurs on the rights of indigenous peoples, the special rapporteur on human rights and the environment. Before that, the special rapporteur on toxics and human rights, the position that I currently hold. There are a number of reports produced by special procedures that get into the environmental dimensions of human rights. And this jurisprudence can also be found in the aggregated case law of regional courts and human rights mechanisms. So the European Court of Human Rights, for example, has a vast jurisprudence that links environmental issues with the right to life, with the right to private and family life. Similarly, the Inter-American Court of Human Rights has vast jurisprudence on indigenous people's rights as it relates to the environment, the right to property, the right to self-determination, the right to life, the right to physical integrity. These rights are all embedded in this jurisprudence, and more recently, in the inter-American context, the opening of the doors for the justiciability of the right to a healthy environment per se, by way of its incorporation into the American Convention system of individual petitions in relation to the standards included in the San Salvador Protocol. I can elaborate more on that on the Q&A, since it would perhaps divert us from the main angle of this talk, which is how this right and this content can help us reverse course in the direction that humanity is moving. In order to identify how that can happen, we need to look at some key elements of this jurisprudence. So this is a key distillation. Some of you may like the word distillation more than others, but discrimination is a key element here. The disproportionate burden of pollution. Indigenous peoples that suffer from the extraction of oil and gas in their territories. Indigenous peoples that suffer from the impacts of mercury that's released into the rivers. These are examples of disproportionate burden of pollution. Discrimination can find other expressions as well, such as when governments provide environmental information to some groups, but not to others. Or where some people are allowed or can, in fact, participate in decision-making and others cannot. This another form of discrimination. In my last report to the Human Rights Council, done in collaboration with David Boyd, Special Rapporteur on Human Rights and the Environment, we elaborate on the right to a non-toxic environment. And in that context, we present extensive evidence of sacrifice zones around the world, places that are so polluted where life of dignity becomes impossible and people are sacrificed in their fundamental rights. Now, this is a direct violation of the rights of those people. It's a situation that is incompatible with the human rights obligations of those governments. And it's not a question only in developing countries. It is also in industrialized countries. I recently had the opportunity in the course of my mandate to visit, to conduct an official country visit to Italy, and visited the town of Taranto, where Europe's largest steel plant is located. There's even a decision of the European Court of Human Rights concerning the pollution that has affected the neighbors and the residents in this town, where the court very clearly says that economic development is not a justification for the violation of human rights. But as I was saying, cases, they are multiplying. This report contains a number of them, highlights a number of them. The case of Kabwe, for example, in Zambia, where children and women of childbearing age have been exposed to lead over decades. There's now public interest litigation going on in South Africa. We'll see whether that litigation goes forward. Recently, I had the opportunity to visit the community of Arica in northern Chile, in the desert, next to the frontier with Peru, where people are to this day experiencing the public health catastrophe of hazardous wastes that were shipped from Sweden to Chile in 1984. I have written, in the course of my mandate, I've written letters to both Sweden and to Chile, urging them to find a solution to this problem, for Sweden to take those wastes back, for the affected community to receive specialized treatment. And this is part, I think, of what international environmental law should also be doing, of cleaning up reparations for the environment and for the people that have been affected. So we see the disproportionate burden of pollution, one key element of the human rights and environment jurisprudence, discrimination, as in this umbrella right of a healthy environment. A second element I wish to highlight is the relation between the environment and substantive rights. So I have mentioned a few already: the right to life, the right to physical integrity, the right to health, the right to a clean water, the right to nutritious food, the right to an adequate standard of living. The right to a healthy environment relates to these rights very intensely, but it relates to perhaps all rights and many other rights in various ways. So this is part of the this is part of the legal analysis that is relevant here. Now, today we find this relation between environment and substantive rights almost obvious, but it wasn't so 20 years ago when this body of jurisprudence began to unfold. This is legally significant because the healthy environment may exhibit the characteristics of obligation that's in relation to the right that is in question. So, for example, if a person is exposed to arsenic and for that reason its personal integrity is impaired or interfered with, there is a question of immediate effect in the content of the obligation regarding the right to life. In other areas, it may be that the question is one of the protection of a forest, and there the improvement of environmental standards may be seen under the lens of progressive realization. So this relation between substantive rights and the right to a healthy environment can be legally significant in those terms as well, in the content of the obligation. I think I'm running out of time, but I do want to highlight that in the content of the right to a healthy environment, the procedural approach is also very important. So the way that environmental decisions are taken, has there been access to information? Has the there been an opportunity for the affected individuals or community to participate effectively in the decision-making process? Are courts open to complaints? So the rationale for this is the qualified deference to state sovereignty. In a way, it's a path of least resistance. It's one thing for a regional tribunal to scrutinize and interrogate the substantive determinations of environmental policy of a country. It is another to ask, well, what has been the process that you followed? Has it been transparent and open and consistent with human rights? This speaks to the functional elements of good governance and of a functional state. So the procedural approach is a third distillation in the content of human rights. So there's so much more that could be said, but the point I wish to highlight is that these elements begin to inject a rights-based approach to multilateral environmental agreements that should exhibit and be designed with the best available science in mind and provide the vantage point of the individual and communities. That's what they are for addressing the shared concerns of humanity. If we have time, we can speak about the plastics negotiations. So in conclusion, we before us as humanity we are in a grave predicament. We have a severe crisis ahead of us today, even, that is threatening to wipe out the human race, the human species. This is what scientists are telling us in relation to climate change, in relation to chemicals and wastes, the inability, for example, infertility, inability to procreate, miscarriages, impacts on future generations. And it's not just humans, it's also the life as we know it on the planet, the biodiversity that exists. How do we inject a human rights-based approach to multilateral environmental agreements? That's where the right to science illuminates the right to a healthy environment, which can help us change the trajectory of the status quo. Thank you very much for your attention. I think I've gone over a few minutes, but happy to take a few questions.
Thank you very much. That was very illuminating, definitely. And I mean, on the one hand, it is disheartening, especially I liked very much your focus on the right to science, because it displays, it shed lights on these two-sided worlds. So on the one hand, where law is legalizing ignorance, I mean, power, instead of knowledge is power, ignorance is power in our world through law. But at the same time, you also indicate an heartening road to kind of reverse course. So that's at least encouraging to hear. And if we have this perhaps over-ambitious title for the seminar, is because we think that hope is a necessary rational emotion to move us forward. So I don't want to abuse too much my role. I just say that we extend a few minutes the session if for you is okay to take some question, and I already see hand raised by Professor Helen Hay. So Ellen, please. Helen, we cannot hear you. And I think you are unmuted. No. Now I'm trying to read through.
I think she's trying to say switch to the next one.
Yes, switch to the next one. I don't see a hand raised, in which case I will abuse my power as a chair. No, I see Kinanya.
I also saw Lisa Lott, by the way. Thank you so much, Professor, for this really interesting presentation. I'm curious how your work relates to let's say, something I'm annoyed by, which is this sort of theory of change that remains to underlie the way we think about progress. So it very much still is about growth and profit and technological progress, and that will clean up after itself. So this underlying tone of economic development will in the end clean up the environment, ensure the innovation that we need, and then we'll get there. So I'm curious how your rights-based approach, which is surely enlightening, kind of counters this sort of, the theory of change needs to change too. Thank you.
Thank you very much, Professor. Hey, did you make the question? No, I can see you in the screen, but I can't see anyone else.
It was Kinania.
Oh, there you are. Okay, thank you. Sorry about that. Yes, thank you for your question. So here we have, in a way, competing areas of policy making, and we could see how those played out in the debates in Rio +20, on the reaffirmation of the sustainable development paradigm. Some people were saying, well, sustainable development has run its course and it's simply a front for more of the same, and we can't just have more of the same. In order to address that, there were debates on how we measure sustainable development, and this can be found in the outcome document of that conference, that it's not only about economic growth. It's the indicators need to be much more nuanced. The UN Development Program was to be working on those. That's also where the Sustainable Development Goals come into play. But leaving all of that aside, I think that the key point in relation to what I am talking about is that in the state-centric view of international environmental law and international law generally, we've come accustomed to the idea that everything can be negotiated, including science, and that's just not the case. We cannot negotiate the science. There are physical limits to the planet. There are certainly those who will argue that technology makes those physical limits illusory. And it may well be that at some point we'll be able to capture carbon from the atmosphere, but that's not the current level of technology that we have today. And so with the technology that we have today, there is a discipline that we must have as humanity to live within our means. And that means also the means of the environment to absorb wastes. So that's a difficult proposition, because part of the environmental law trajectory has been to try to find that level of optimum yield in fisheries when it comes to natural resource extraction or in forestry management, or how much waste can ecosystems tolerate. Now that paradigm is failing. It's failing us. We're not seeing the complexity, and we're not seeing it for the two reasons I mentioned, because science is not being regarded fully, and because the state is often being captured by economic interest. So in the face of that, we definitely have a heavy challenge ahead of us.
Yeah, thank you. So I may not see hands, so I'm okay. I see Ioannis. Ioannis, please.
Yes, thank you very much, Professor Orellana. That was very enlightening and indeed powerful. Sorry, I'm just looking at the other screen, but I see you. So my question was about, in a way, I wanted to hear how you would relate your human rights-based approach to rights that are usually conducive to economic development, but have traditionally been criticized as obstacles to addressing issues of environmental justice, and namely property rights or contractual freedom. So how do you see a rights-based approach, the potential rather of a rights-based approach for environmental justice, considering that within a rights-based approach, one has to contend also with very strongly enshrined rights in the tradition of human rights, such as property rights.
Yes, yes, thanks. And the nuances here have unfolded in different paths in regional systems, and we can see, for example, in the Americas, how the right to property in the American Convention has been used to safeguard the rights of indigenous peoples to lands, territories, and natural resources, also in relation to self-determination. Whereas in the European human rights context, it has been used in the ways that you mentioned, in safeguarding economic activity, but also it has been used in elaborating on the legitimacy of environmental regulations for the public interest. We could talk a lot about the margin of appreciation and so forth, but I think that the example or the question that you're raising can be addressed through a real world situation that I'm facing with respect to mercury. This is going to be my next report to the Human Rights Council. And so in those debates on the Minamata Convention that regards mercury as an allowed use, the argument is often made that the miners that use mercury, they're poor, they need a source of livelihood, they have the right to an adequate standard of living. Banning mercury would be counterproductive because it would displace them into extreme poverty. Now, I think the answer to that is that it is certainly the case that minors have human rights as well. There's no doubt. But human rights does not justify imposing harm on others. So the conduct of private activity, and that has expressions for the right to implications for the right to property or for contractual freedom, none of that can justify imposing risks and harms on people that are not in those contractual relationships. And that's the situation that indigenous peoples are suffering in the Amazon, in other places of the planet as a result of mercury emissions. I think that example illustrates the tensions, but also the way out of it, the way that they need to be addressed so that no one is left behind and no one is sacrificed for the pursuit of the profit of somebody else.
Thank you. So now I see two hands raised, Professor Hay and Professor de Jong. I suggest that we take both set of questions and then they will be addressed together. Ellen.
Thanks, Alessandra. This is supposed to work now. A colleague showed me how to make this work. Thank you very much, Marcos, for a wonderful presentation. I would be very interested in what your thoughts are about what's happening in various in the work of various mandate holders, various UN human rights committees, where it's not only the state that is the addressee of the duties, but increasingly also private sector actors. There's now a number of general comments that I think most of them are still in the make. A number of rapporteurs, I don't remember, but probably including yourself, have raised this. And I would be interested to hear where you think the future of this new development, where human rights bodies and treaties are now seriously taking on also the private sector, where you think this might lead us and where this might go. Thank you.
Let me then follow up immediately. I follow you in your whole argument, as well as the radical edge of your message. But I have one qualification. To quote you, science is not negotiable. Now, the difficulty is that scientists often disagree amongst themselves. And that makes the claim that science is non-negotiable a little weaker. It opens the door to other outside forces to say, you know, there is a third and a fourth and a fifth voice that is also scientific or quasi-scientific, and that can be used against the first and the second that probably were more honest or more authentic and more based on real data. So my question to you is, do you think it's tenable to claim that science can speak as one voice? Or would you rather say, no, actually science is internally differentiated, and that doesn't make it meaningless, and it doesn't mean we can haggle with it, but it does mean it's more vulnerable to outside influence, which may be of a mercenary kind?
Shall I go?
Please.
Thank you for those reactions and the questions. So on the private sector, I think you're perfectly right in that there is increasing appetite and attention by special procedures and others to find ways for holding corporations accountable for environmental damage and harm. The state-centered or state-centric view of international law makes this very difficult. Even the negotiations at the Human Rights Council of a new treaty on transnational corporations, their business enterprises in respect of human rights, is taking that approach of requiring states to control their corporations or corporations within their jurisdictions. There are issues of due diligence there. It's not that that is not important or useful. It could become a game changer if it's done in a robust way. Due diligence initiatives in Europe are progressing in that direction, and there's a lot that could be unpacked there. But I think the bigger implication of your question is on how we see international law. And we have, I think, we here, the invisible school of international lawyers trained in the UN Charter-based worldview, have taken Article 38 of the Statute of the ICJ as the sacrosanct tables of the sources of international law, if I can speak with that language. And that well, it may have worked when it comes to state responsibility for traditional issues of state coexistence, but when it comes to international environmental law, which is about different issues altogether, yes, coexistence, but existence as humanity and cooperation, that catalog of sources is not well placed. And so if we begin to think about holding corporations accountable, we may need to also begin to think of widening the range of sources of international law and the enforcement mechanisms. So as a kaleidoscope, the metaphor has been used, or as a mosaic that can integrate. Now, the challenge there is on the legitimacy of the use of state force. So when is it legitimacy to enforce through that? And that's where Article 38, as given its reliance on consent, a strong reliance on consent, not exclusive but strong, is important. But I think that is the big implication there of widening the ways that international law is recognized, it is made, it is applied, and so to come out of the pigeon box of the Article 38 of the statute. And on the second question, I fully agree. The science is not monolithic. It is not that it comes to one voice, and there is negotiation, indeed negotiation understood as a process of debate and dialogue between scientists, and that's what we need. We need scientists to be able to discuss, and that's where human rights also play a key role in the scientific process of freedom of expression, access to information, freedom of assembly, and so forth. So the scientific method, in a way, is intrinsically linked with respect of fundamental human rights. And because it doesn't arrive necessarily at one voice, that's where the tools of environmental law that have been also embraced by human rights, such as principles of prevention, non-regression, principle of precaution, are so important. But yeah, I agree with the premise. Where I'm saying is that the politicians and the delegates and the diplomats it can't negotiate the science. That's for scientists to come up, and that's also where the best available science is incorporating those voices that are voicing concern about risks, and they may be in the minority, but that is not an obstacle for governments to act upon them in order to protect their populations and more broadly.
All right, thank you very much. I would have a question, but I'm afraid I will have to keep it because we are slightly over time. I would have asked about, the role of local communities in all of this, because there are very interesting dynamics also in terms of science of knowledge production from the bottom up. But I'm afraid I have said, and I hope we will have the occasion to converse at another time. We are really, really grateful for this terrific lecture and engagement with us. I think we have a shared ideal to try to change how the status quo is at the moment. So thanks again for the input and the hope you injected. And we hope to see you soon at Erasmus University. Thank you.
Thank you very much for the opportunity to join the conversation. I very much enjoyed the questions. I wish I could be there in person. I've tried to be as provocative as I could be, with a bit of had to shake things up. And so in that sense, straddle a bit the rigor of academia. But I do share the sentiment that law has a critical role to play in changing the status quo.
All right, perfect. And with this, we take just a 5-minute break to fill up